Good morning, everyone. I would say I'm delighted to see you all, but obviously by the magic of Zoom, I can't. I am, however, delighted to introduce my partner, Martin Chitty, to present this webinar to you today. My name is Jonathan Chamberlain. My function is to chair, which means to introduce Martin, and to keep an eye on your questions. I think by now, most of us are familiar with how Zoom webinars work, but if you use another video platform, then can I direct your attention to the Q&A button at the bottom of your screen? If you do have a question for Martin, please tap that in as soon as that occurs to you, prompted by something that he says. Martin won't be taking questions as he goes along, but he will be taking questions at the end. The idea is he's going to speak for about 30 minutes. So we're leaving 10 to 15 minutes for your questions, which we will pick up then. So our topic today is fire and rehire. I'm not going to steal Martin's thunder by referring to the P&O episode, but this is a topic which has been in the news very recently. And I suspect the way the economic winds are blowing will continue to pop up in the news from time to time on an increasing basis. It's highly controversial. If you like that sort of thing, it's highly entertaining, as is Martin. So, Martin, over to you.
Well, Jonathan, that's very kind, and good morning, everyone. I know from reading the list of delegates that there's a number of clients who I've worked with out there. There are even some former colleagues, and it's always nice to welcome guests from other law firms who've logged on to see what we've got to say and what we think about this. So let's start by getting a couple of quick disclaimers out of the way. I'm not going to talk solely about fire and rehire, because that's just one of the arrows in the quiver, to use Mr. Johnson's phrase. What I'm really looking at here is the options open to you and the things you need to be thinking about where you're looking at reducing either capacity or headcount or cost, because there's more than one way of doing that. So that's the first disclaimer, which is that's what I'm really talking about. And the second disclaimer in all of this is that I profess no inside knowledge of what P&O did or didn't do. I've not seen anything that you haven't all seen in the press or the media. But the one issue I think we ought to think about, and it's the same for all of us in all situations really, and what you and we try and do when we're talking to businesses and to clients, is to identify the nature and extent of risk and the appetite for risk. And therefore, if the business, you or we, are going to take a particular path, then we do it consciously. And that's the issue, I think, really, that the P&O case teaches us. And we'll come back to that in due course. So, as ever, we're going to have a bit of an agenda slide. Here's the agenda. And the issues here I want to look at really divide into two parts. The first, if you like, are the context. What's our situation? What are we trying to do? What are the levers that we're subject to? That might be urgency. It might be restructuring. It might be all hands to the pumps, no pun intended in terms of P&O, of course. So there's context and there's the options. You know, what are the choices we have to consider? And I want to stress this at the start. The options that you consider, it's not simply a case of identifying one path which you're then going to follow, although ultimately that is what you are going to do. But you need to consider what the alternatives to that path might be and why they don't suit your purposes. Because as I'm going to talk about, if and when you get into collective consultation, you've got to expect that the trade union movement or the staff side, however they're represented, elected reps or not, are going to be pushing back and say, but what about this? What about this? So if you haven't thought about those things, you are going to be underprepared. And if you're underprepared, it's like anything else, that it increases the risk of it going wrong. So if you like, the first two issues, A, are context and options, and the B issues are time, risk, and reward. And by that I mean, how long have we got? How urgent is this? How do you want to take time doing it? Because the more time you take, the less risky the process should be. Or do you want to take a more accelerated approach to all of this, a heightened risk, but The reward from your point of view is a combination of time saving, and that might be something as mundane as not spending the next several months locked in hand-to-hand combat with staff side over the process and selection. It might mean that it's perfectly obvious to many people involved whether they personally are going to be impacted adversely by this. So we save the time of them knowing it's going to happen and just waiting for the axe to fall. And the third limb of this, if you like, is the reward side of it. Now, and that's a slightly crass way of putting it. What I mean is this: what's the upside for the business of getting this done in a particular way? The upside might be time saving, it might be lower risk, or it might be that there's a benefit to, you know, if it's got to be done, let's do it quickly, which is how P&O decided to go about it. And the issues there, if you take all of those, you know, the risk, reward, and time issues are the B issues, if you like. It's not a ranking order. So we've got A plus B, and that equals C, because those two sets of issues together then define what the process is that we're going to need to follow. So that's our agenda, if you like, and everything that I'm going to talk about really relates back to those agenda issues in some way. Let's have a look at options here. And this is where I want to take it slightly wider than simply the question of pure, what I might call old school redundancy, which is simply headcount. Because I think we've seen over the years, and Jonathan and I have been doing this a little while now, many of you will see the evolution of cost and capacity change over time. So if we wind back 20 or 30 years, the knee-jerk reaction almost in a slightly unreconstructed way was to go for headcount reduction. And that could be classically either a place of work would shut, we would take out a particular service line, or it might be that we reduce the number of people doing something. All of those are classically redundancy criteria, and you'll have come across them many times before. So redundancy works on the basis that you have fewer people, consequently the wage cost generally is reduced, and you may or may not have the same amount of work being done, and that really depends on how you configure the business going forward. And each of these options has a different set of variables in it from that point of view. Fire and rehire, I suppose, is as Jonathan says, a pretty politicized topic. There is talk of it being made unlawful. At the moment, that's not the case. It is perfectly lawful, and there are some risks attached to it, which I'll come back to later on. But if you fire and rehire, generally what you're doing is you're retaining the total number of people in the business and the skill set, the collective wisdom and experience that all of those people have. You're retaining all of those people, but you're looking to reduce the cost of their wages, the cost of employing them, because you need them all to stay, because you've still got the same amount of work to be done. So this is purely cost reduction as opposed to classic redundancy, which is also about capacity reduction for the most part. And where we see fire and rehire most commonly is in situations where businesses need to reduce an element or a proportion of their wage cost overall, normally where they're under tremendous pressure from customers or clients actually to reduce what they're charging. And we've seen this a lot in outsourced public sector services, for instance. Now, replacement, what do I mean by that? That's the very antithesis, isn't it, of redundancy, where we're not reducing the number of people, we're merely replacing them with others. So I'll give you a live example of this. A couple of years ago, we worked with a significant client of ours on an exercise where they went into consultation having already done one redundancy exercise on the indirect cost base on the white collar part of the business, and they were looking at the manufacturing basis, which wasn't in a position where it needed to reduce capacity, but there was an interest from the client in reducing the cost, and that was because their internal wage structure and grading structure automatically moved people through grading bands based solely on service rather than competence. Not unusual, particularly in manufacturing. So it's a very sort of old-fashioned service-based approach to the world. And what they looked at, and they went into open consultation with the union side on this, and a very experienced union at that, very sophisticated, and said, okay, we would be interested in achieving a cost reduction and a slight reconfiguration of the workforce, the age demographic particularly. And we are prepared to fund some incentivization of people if they want to leave. And the union's reaction, and the client accepted this immediately, was to say, right, okay, we are prepared to progress that with you, but only if you commit to a like-for-like replacement of those staff members. So there's no overall reduction in jobs, which is a win for the union, but we are prepared to facilitate, if our people are up for it, in this process. And what they did was agree upon an incentivized early retirement package, in effect, provided that people were then replaced. And all of those people came from the agency pool of workers, so they were known to the business. And the upside for the union, apart from retaining the total headcount, was whereas the agency workers generally are not union members, those who come onto the full-time staff generally do then join the union, because historically the unions work very effectively to protect their position. So we end up with the same number of people doing the same volume of work over time, but at a reduced cost to the client. That was very effective. The numbers worked very happily, and the whole exercise was self-funding within 2 years. Why do I mention part-time? That doesn't look like redundancy, and it's certainly not fire and rehire, is it? No, but it's an agreed variation to the pre-existing work pattern. It results in the same number of people, their skills and experience being retained. It reduces the cost of the business, albeit that it might result in less work actually being done. Although there are studies coming out, I'm sure you've seen them as well, which indicates that people going to a shorter working week can actually lead to an increase in productivity per hour worked, pure measure of productivity, so that the volume of work done is in fact the same overall. And that's obviously advantageous to the employer from that point of view. The last one of these is a pure variation. So this is the approach we would take before we get to fire and rehire, which is simply look to agree with people that we will change their working terms and conditions. It's not as aggressive a fire and rehire, obviously. It's vastly preferable because it doesn't trash your employee relations or your industrial relations environment, but hopefully you will achieve a reduction in cost from the business's point of view. So all of these are alternatives which I would suggest you should be thinking about, because if you're not, staff side union certainly will be thinking about them. And what we've seen over time, and certainly around the financial crisis of 2008, we saw a movement away from the pure redundancy approach of simply slashing headcount to a means of ensuring that the aggregate skills and experience within the business were retained at lesser cost. So we saw lots of clients going on to a shorter working week. And I think there's much more flexibility in terms of mindset overall on both sides, on the staff and on the management side, over time from that point of view. So why are all these issues linked, apart from the fundamentals of the fact that they're designed to reduce cost to some degree? Well, the real basis for that is legal. Frankly, that's why I'm trying to tie them together. They all require engagement with staff, patently. They all require some degree of process, and that might be collective process. And we'll come on to how and why that works. But there's also a requirement around individual process, whether it's consultation about individual selection for redundancy, or whether it's a consultation process around a variation to contract. And the legal context for that, it's not just a nice to have, it's necessary, there's an obligation to it, is that if you go above 20 people being dismissed through no fault of their own, then you have to engage on a collective basis. That's either with the trade union if you have one, or with elected employee reps if you don't. And that, if you should have done it but don't, can get very expensive, because as we'll talk about later, that can incur a cost of 90 days pay per person affected. So immediately, if you should have done it, but you didn't, you incur a cost, and that undermines some of the cost saving which you're trying to achieve through the variation or the redundancy process. And that, of course, all leaves aside questions of unfair dismissal, possible arguments around discrimination, claims, loss of management time. So all of these things are linked because all of them ultimately come down to that combination of risk and cost. And these are the things which all of us in this session today are looking to either avoid entirely, minimize if we can't avoid them completely, or alternatively, take a known decision so that we've got a measured degree of risk. So what I'm going to do next is talk a little bit about a quick recap. It's difficult in sessions like this to know exactly what the level of experience is in the room. And I thought what I'd do is divide this into two parts. So this is really another hour-long webinar on its own, which I'll try and reduce to no more than 5 minutes, which is a quick recap about some of the do's and don'ts around collective consultation. Because if you're dealing with significant numbers of people, it's almost certain, although it's not impossible, but it's almost certain that you will need to engage in some sort of collective consultation exercise. So these are the headlines. More information is available if you have a look on our website, and there's some background information there. So for those of you who've not needed to go through this previously, collective consultation is a numbers game, and the numbers work in this way. If you have less than 20 people being made redundant at one establishment, I'll come on to what that means in a minute, in a 90-day period, then there is no obligation to consult collectively. However, if it's between 20 and 100, the obligation is to consult over a 30-day period before notice is given. Important caveat there. And then if you go over 100 at one establishment, the collective consultation period is 45 days. That used to be 90. It's not. That was reduced actually some time ago now. So it's now down to 45 days. So that's the starting point. What are the issues which might drive how we look at that? Well, the first is if it's a pure redundancy, that's relatively straightforward. How many fewer people are we going to end up with? It's a broad measure. If, however, we're looking at something like a variation process, we may not know how many people will leave, so we may need to be cautious, at least consider carefully at what the end game might be. And why I mentioned earlier that this is about dismissal where it's through no fault of the individual, it's impersonal if you like. Classic redundancy is caught by collective consultation, but so is dismissal where, for instance, we haven't managed to agree a variation and we have no alternative other than to fire and rehire. And if we haven't gone through a collective consultation process before then, it's going to take us up to another 45 days plus notice periods before we can do that effectively and safely without running the risk of a significant award. So that's the pure numbers element. Obviously, this depends on how many people are affected at each establishment. And an establishment for these purposes, without going through all of the history of the court cases all the way up to the European Court, is really about a place of work. Where do these people identify they work? Now, if as a result of that, you can say, well, overall, we're looking to cut 101 people out of the workforce, but there is no single place of work where more than 20 are likely to be affected, then you won't be subject to collective consultation at all. So it's an important point to start digging down into the detail at a fairly early stage, because it may be that you can short circuit the process. And to give you an idea of how that might work, if at one extreme, you've got a workforce working across lots and lots of sites where no more than 20 people are affected at any one site, and the workforce has grown very quickly, so you've got very few people with more than 2 years service, the consultation period may be very limited because it's individual only, because nobody is at risk really of unfair dismissal claims or has an entitlement to redundancy pay. Whereas at the other extreme, if you've got a single place of work where there's lots of people affected and they've all got more than 2 years service, you could be into a consultation period followed by notice, possibly, and work notice, where that could run up to, at an extreme, 150 days, if you haven't already got a trade union in place, because you'll need time to elect reps, those sorts of things. So the timing of all of this is one of our key variables. The timing of all of this, how we need to approach this, does vary considerably from case to case, situation to situation. And it's well worth spending a bit of time at the beginning working through this sort of exercise. It's surprising how often we find that there are ways of ensuring that perfectly legitimately and properly you could avoid the need to consult collectively, although you may choose to do so because you are the type of organisation that will do that. Now, I've mentioned several times as part of this process that we have to talk to the trade unions or elected reps. So the question then is, well, do we have a choice? Well, no, we've got to do it. So there's no choice there. And we don't really have a choice about who we talk to either, because if you have a recognised trade union, then the obligation is to talk to them. You can't talk to elected reps when there's already a union in place. That was the position at one time. It's certainly not these days, hasn't been probably nearly 20 years. If you don't have a recognised trade union, then you have to put in place some sort of representative group. Now, in some organisations, you may already have some sort of employee forum. The risk there, and the thing to go away and check at an early stage, is whether they're properly mandated to talk about redundancy. Some may be, lots won't be. And then whether the people who sit on that panel are actually from the affected group. Because if they're not, then it's going to be inadequate. So you always have to think about putting reps in place, and that may mean elections if there are too many volunteers. The process for that is very open, very flexible. There's no minimum number of reps. There's no fixed criteria on how they should be, who they should represent, whether it should be by location, grade, function, and how it's to work. You can decide all of those things. But there is an issue there about timing, which I would mention, particularly at this time of year, and it's why, generally speaking, we don't see redundancy exercises in July and August, is that in non-union organisations where the reps have to be elected, clearly those on holiday around school holidays aren't going to be part of that process because they can't stand and put themselves forward. So you do need to think about that. The other thing to think about is the length of notice. There is quite a formal and prescriptive process in terms of information to be provided to the union and to reps. There's also a form called an HR1, which if you don't file it, you can be prosecuted for not doing so. Now, 5 years ago, I don't suppose Jonathan or I would have seen that as a massive risk. I don't think we'd ever seen an example of it happening in practice, but more recently, that has happened in a couple of high-profile cases, albeit they haven't really got to a conclusion at this point. But don't put yourself in harm's way. Don't put the organisation in harm's way by not filing an HR1. The other thing to think about is that the obligation to engage in consultation may arise slightly earlier, indeed considerably earlier than you might expect, depending on the nature of the organisation. Under English law, consultation, the obligation arises when the dismissals are proposed. In the European law, it's slightly earlier. So for emanations of the state, it will be when they're first contemplated. And as an example of both of those things, if you like, if you go into a process of attempting to vary contracts by agreement, but you know that if that can't be done, if we can't reduce wage cost in that way, we will be making people redundant, then in effect that's already proposed, isn't it? So the obligation will have been triggered slightly earlier than we might have expected. The last point I'll notice, and this does affect timing, is strictly speaking, you can't give notice to dismiss until the collective consultation has been concluded. It's possible then, of course, to make payments under notice or deal with it otherwise by agreement. But in some circumstances, and you do need to think quite hard about this, you need to consider at the outset how you're going to deal with notice. Are you going to pay people in lieu? Are you going to put them on garden leave? So the consequences of that are the same. Are you going to have them work. And of those options, in my experience, having them work is the least attractive, because people working out lengthy notice periods, particularly in a situation like redundancy, rarely works desperately well. The other quick point to recap on fire and rehire is it is caught by section 188, because if we get to the point where we dismiss an offer to re-engage on different terms, then it's a no fault based dismissal, so we should have dealt with it on a collective consultation basis. So there will be instances, particularly if you want to save time, where you go into this making very, very clear that if an agreement can't be reached voluntarily on wage cost reduction, you will be proceeding to dismiss and re-engage. And if you don't make that clear at the outset, and you don't run through all the collective consultation steps, you're going to have to stop and then start all over again, which is going to elongate the process even more and defer the realization of any cost savings. Something to think about here as well is the potential for unfair dismissal claims. Now, you will all know that where you have a situation of redundancy, where people have got more than 2 years employment, they have a right to a redundancy payment, and if they don't like the process, they can claim unfair dismissal. The same arises in relation to fire and rehire type dismissals. Their claim is, your defence to the claim for unfair dismissal is that you've got some other substantial reason which justifies the decision to dismiss. The fact is, though, that that's actually very difficult for an employer to satisfy, because you would have to show that, but for getting the variation in place, the company's very existence and solvency would have been challenged. So it's always an uphill struggle, but it's still dependent on those with more than 2 years service having the right to bring the unfair dismissal claim in the first place. Now, that's taken slightly longer than 5 minutes, as it was always likely to do, I'm afraid. But what I want to have a quick look at now are the more practical issues here, in terms of the competing pressures to which you're subject. And if we go back to the opening of this, which is, do you want to avoid being P&O? Maybe you do, and rightly so. You may not want to attract all the adverse political and media attention and possibly brand damaging reaction at that. But it may be that you decide, however unattractive it looks at the outset, that you're going to take a conscious decision, which we'll come on to. So the timing here is key. The question of whether there are immediate risks and how you want to go about the restructuring, the realization of cost savings, is going to be driven by timing and the position in which the business finds itself. There are reasons why you can avoid the obligation to consult collectively. These are what are called special circumstances defences, but they are absolutely a last resort. They're only really looked at positively by the tribunals where the company would otherwise go bust in the very short term. And even then, it's an uphill struggle to bring the argument in the tribunal. So if that's our only argument, it's probably not a very good one, but we should be doing something rather than doing nothing. There's definitely an issue about the balance between risk and cost, as I've talked about already, and this risk of, if we don't go through adequate and proper collective consultation with a view to reaching an agreement about terms of severance, about the rationale for all of this, about selection processes, etc., then we could be on the wrong end of the claim. And that claim is not, oh, it could be 90 days, how badly will it go? It's the other way around. It's a fine, it's a penalty. It starts at 90 days and is then discounted by the tribunal if they think you did something rather than nothing. But it's worth remembering when you're talking particularly to finance to say, okay, but if we do it that way, it could cost us 90 days pay per person, which is unfortunate, as I say, undermines the proposition. I think in practical terms, the implementation of business dislocation is a huge risk. There's different ways of looking at this. If you're closing a plant, then it might be that a clean cut-off is always going to be the approach you would take. If you're going to take out a layer of management, it's probably best that it was done quickly and you can realize the change. If you're being selective in your redundancy, so you're reducing a particular level or the workforce entirely by, let's say, 30%, which is really very material, isn't it? That's going to have a massive adverse impact on morale, motivation, attendance, productivity, etc. So there are lots of reasons why you may want to foreshorten that. And that's open to you to discuss with the reps as you proceed, particularly in terms of incentivizing almost engagement. Because if you say to people, well, look, whoever goes will be unable to go with full notice pay without having to work a day of it, there is some incentive to that. They're no worse off, but you don't have to have them in the business, and they don't have to put up with being marked men and women who everybody knows are about to leave, albeit it's not their fault, but they're still being dumped. And the emotional reaction to that can be considerable. I think reputation and brand damage are definitely things to consider, but they are things which you might regard as tolerable. Query, and I have no insight on this, as I say, what has been the long-term brand damage to P&O out of all of this? Yes, they were sort of acquired pariah status for a very short period, but they're still loading cars and lorries, as far as I know. The government's reaction and the, shall we say, attentive and zealous approach of the Safety Inspectorate to the new crewing arrangements meant, in fact, that the people really disadvantaged, and I'll come back to this, by the process were people wanting to go on holiday by ferry at Easter, because 45% of the ferry capacity out of Dover was not working. But undoubtedly, you need to be prepared for some big and small p politics in all of this. Local and national politicians, in some circumstances, will use it as an opportunity to get themselves some much needed publicity. So I've got a couple of more thoughts before we finish. There's always the question here of, are we going to do this by the book, which is lengthy consultation, lengthy individual consultation, notice being worked, etc., or are we going to do this by a bit more intelligent design? Are we going to contemplate looking to sweeten the approach here, or take the risk that we might have to pay the price later? Those are commercial decisions for you, but certainly they are issues to explore. And by paying the price, if we do go back to stuff about P&O, which is in the public domain, you'll probably remember that there was outrage, particularly about the way they chose to implement this. You're getting people together and then broadcasting their dismissal. Crass, one might say, not how any of us would think it ought to be done, really. But it was accompanied by an extremely generous severance package of about 200% of the most they could otherwise recover. And within 1 week, I think there was only one person who hadn't signed up to the deal of the about 800 people who were given notice. So maybe the design approach did work in the end. As I said, where you're dealing with a complete closure, it's more straightforward, although no less brutal, than selective reduction. So it may be that you really want to think about which of those methods you want to adopt. There is a question, this did come up in the P&O case, didn't it? Where almost the question was, well, isn't this just an outsourcing exercise? Aren't they just passing over the crewing to a third-party agency? So why are they going about it in this way? And sometimes you will need to think about whether that is in fact the underlying issue, because there are wholly separate and different sets of obligations about collective consultation, if that's what you're doing. You could work back from the end point, couldn't you, and say, well, okay, the worst possible scenario here is X. Let's say we don't consult, we go down for 90 days pay. We've still got notice pay and statutory redundancy pay. We can't avoid that. So the variables are unfair dismissal claims and absence of collective consultation. So the worst case scenario is A plus B plus C plus D, all of those. And then we discount that and we put forward some sort of package in place. The incalculable element of this is the political and brand damage. And you'll know more about how that would impact in your particular market than I can possibly say, but it's in there and should be in your thinking. So the final 2 points, could you pay your way out of trouble? Well, the answer is yes, and that's exactly what P&O did. I think they did that on a very calculated, predetermined and considered basis. And you put in place settlement agreements, which they did. That precludes any further claim. Or does it? Well, settlement agreements preclude individual claims. We all know that. All sorts of individual claims, contractual, statutory, etc. What settlement agreements don't do in situations like this is they don't deal with the unsettleable claims. And what I mean by this is that there isn't actually a mechanism short of ACAS conciliation after the event where you can pre-agree to settle prospective claims for lack of collective consultation. And that's the big ticket items, and that's always a risk. There are ways of doing this. Jonathan, I've recently done a case involving the settlement of quite complex industrial relations dispute and an outsourcing arrangement tied together, where there were prospective claims for all sorts of absence of consultation, but wording was agreed eventually. But the fact that you can't use a settlement agreement for that makes it slightly more cumbersome. The other thing to think about is that if you've gone into this honestly believing that you've planned it well, you've looked forward, you've done all the right things, then putting forward a settlement agreement without any sort of incentive might look a bit weak and as though you're worried about claims being made, or equally, it might identify that the individuals should be pushing for a bit more money. And people will do that, and that's often the key to getting these things away. So that's what was the end of what I've got to say. I'm looking forward to your questions, and I'm going to hand back to Jonathan, who's going to be asking them in his best Jeremy Paxman voice, of course.
Some questions, Martin. Thank you very much, but hopefully none too Paxman-esque. So one question that's come up, and we do get asked this quite a bit. In a collective redundancy, fire and rehire situation, what are the employer's obligations in terms of training employee reps? Do employers have to pay for them to get legal advice?
No, they don't. There's no obligation to do that. Many people would say that would be an excellent idea, but there is no obligation to do that. What we have seen, and what we do in some cases, is we will provide, through people not dealing with the actual advisory part of the process, we'll provide some training for reps, because individuals in a non-unionized environment who find themselves as reps are actually I think in a very difficult position, because they've been selected by their colleagues, or they've put themselves forward. One may question why they've done that, but they have. They've put themselves forward, they volunteered, but suddenly find themselves as the interface between management, who are trying to push through a change agenda, and their colleagues, who are at risk of losing their jobs. So they're unlikely to be able to satisfy everybody all of the time, and they may well feel pressured. So them understanding what their role is, what they can do, what they can ask for, and which things they can't ask for is actually very useful to give them a context within which to work. Otherwise, I think there's a danger of them just drowning. The other thing to think about is that although you, as an employer, don't have to pay for legal advice, you don't have to provide training either, there is going to be a need to provide some sort of facility, probably easier these days using things like Zoom, for them to be able to cascade information down and take feedback from their people, because that's part of their role, isn't it? You are consulting with the reps, not with the whole of the workforce on an individual basis during the collective phase. So there's something to think about there. And employers just saying, well, we're not going to help with that, really doesn't get the job done, and actually would undermine the process, in my view, leave you at risk.
Thank you. One question that's just come in, and I think relates to your last slides, is definitely worth picking up. Just to confirm, are you saying that settlements agreements do not cover the failure to collectively consult?
That is my view. There is a process you can go through. ACAS pre-claim conciliation does seem to allow for it, but it's not clearly expressed anywhere. So there's always been a debate, continues to be a debate about that. It doesn't mean that people don't do it. The way in practical terms is, if an agreement has been reached with union endorsement after a period of consultation, and they have signed off on it, if you like, it's going to be difficult for them to backtrack on that. And it's not a situation where individual employees can pursue a claim where they're disgruntled by the fact that they didn't think the union did a good enough deal, or all the elected reps, because the process doesn't require that everybody's happy. The process requires that you've consulted through the relevant collective process. And if you've done that and it's been agreed, so much the better. But it would be useful if the government got around to amending the relevant legislation to enable employers and unions and reps to be able to expressly agree that any prospective claim has, there aren't any grounds for that, in the same way that we do routinely with individual settlement agreements.
And just to add, by the way, for what it's worth, it's my view as well. And it is a very commonly held view amongst employment lawyers. It may be just a lacuna in the statutory drafting. Yes, and in practice, it doesn't often come up.
No, I'd agree with that. It doesn't often come up, but sometimes when we're, identifying risk, the fact that, it doesn't often come up, or it might not happen, and then we're the 1 in 1,000 case where it does, nobody's going to thank us for that. But the case that Jonathan and I was alluding to earlier recently dealt with, we did manage to reach an agreement with the union, which from memory was covered as part of a pre-claim conciliation process via ACAS. I don't think any of us questioned ACAS too hard about whether they got the capacity or jurisdiction to do that. They seemed happy with it, and so did everybody else.
And it was a jolly good deal, I seem to remember.
So a jolly good deal for everybody.
Moving away from fire and rehire a moment, and on to a more straightforward redundancy situation, perhaps. Is there an obligation on the employer to offer voluntary redundancy?
Right. This is a question I should have picked up. My apologies. That's a sort of a yes and no, really, because voluntary redundancy is still a form of redundancy. Generally speaking, it's very worthwhile to see whether you can get people to go rather than having to select them if they're prepared to jump. So does it meet the statutory criteria for avoiding a redundancy? I would say, strictly speaking, no, but presentationally, it's a very good idea. It's something which unions generally will look for. A lot of staff side elected reps will look for it as well. It works best, in my experience, if people are incentivized to volunteer. So they've got to be offered something or have the perception that they're getting something they wouldn't get if they didn't volunteer. Otherwise, why would they? The consequence of that can be that you don't always get the right people to volunteer. Every employer in every redundancy situation will have an idea of who they would like to lose. I think if we're being candid about it within these 4 walls. So how do you incentivize the right people to go? Well, make it attractive, and make sure that you're, as people call it, policing the exit gate, so that as an employer, you can say, well, you can apply, but we decide whether you go or not, so that we have some choice. We don't just lose the people. Otherwise, we face a situation where some will go, take the money, but they're the ones who can most easily obtain alternative employment. They might be our better people rather than our less able people. And on a selective redundancy exercise, it tends to be those who are less able who lose out. They may still be perfectly competent, but they're not as able as some of their colleagues. So a good idea. Think about how you're going to incentivize people to do it.
Thank you, Martin. We've got a cracker of a question here. In a fire and rehire situation, where changing terms and conditions, is there any risk of unfair dismissal claims asking for reinstatement on the old terms and conditions?
Okay. Yes, I'm sure you can identify who's asked that question. I will be asking for their contact details later. Well, there is that risk, because if we think through it logically, we're dismissing and re-engaging. So a dismissal is still a dismissal. If the individual accepts the new offer, then the re-engagement is effective. And I think in most circumstances, that would preclude the possibility of a claim, although there is an argument there. You could always put in place a settlement agreement to preclude that, should you want to do so. If people put forward, if you dismiss an offer to re-engage contemporaneously and they don't take it, then plainly there is a risk of unfair. Well, there isn't. There's a claim. If they've got more than 2 years service, it's for unfair dismissal. It then comes down to the strength of whether we had an other substantial reason that justifies the dismissal, which I've said is difficult. But if they get through all of that, then it is possible that they could go for reinstatement on their former terms. I think it's, well, there may be lots of reasons why that would be unlikely in practice. There's trust and confidence issues. And if the situation was as bad as the employer presented in terms of, you know, a mass dismissal and re-engagement on lower terms, it may not be feasible, and the tribunal would have to look at that. And if you haven't convinced the tribunal of the merits of your argument, you're going to lose anyway. So reinstatement is perfectly possible. But it's certainly something which I think we're seeing reinstatement and re-engagement pushed harder, despite the general buoyancy of the job market. Generally, that tends to happen when the job market is depressed and people can't find alternative work easily. And there are some other issues around orders for reinstatement and re-engagement, which can make it attractive, particularly when the employer is known not to want the individual to come back, because there are enhanced claims that you can make, although it's still open to the employer to decline the order, provided they're prepared to pay the penalty. And there's something, I think, in one of our recent briefings on some cases in that respect, which are slightly counterintuitive in the way they've been decided in the awards that have been made.
Indeed. And I think that brings us to our 11, or just over our 11:45 end time. Thank you very much, Martin. Thank you all for attending. There is an electronic happy sheet to ask for your comments and feedbacks, for which we would be hugely grateful if you wouldn't mind spending a few seconds to fill them out. And we look forward to seeing you on our next session. Thank you very much indeed.
Thank you.